Hey everyone, welcome to the New Frontier, where we attempt to add just another grain of information to the vast ocean of knowledge that is the internet, especially as it relates to public policy. Today, we're talking about Connecticut's ridicule law. Now, what is a ridicule law? Good question. It's an extremely rare type of law that's considered unconstitutional and isn't really present in any state, which is why it's at issue right now in Connecticut. Connecticut legislators are considering finally repealing this law that punishes people that publicly use insulting words or slurs. This year, it might not seem surprising that people are being punished for saying something wrong or insensitive, but that is social punishment. It's not criminal punishment. The Constitution protects against criminally punishing people for saying something just because it's offensive. In fact, offensive speech is often what moves forward social change in our country. Now, in Connecticut, the statute that I'm referring to, specifically a ridicule law, states any person who by his advertisement ridicules or holds up to contempt any person or class of persons on account of the creed, religion, color, denomination, nationality, or race of such person or class of persons shall be guilty of a Class D misdemeanor. Now, what does that all mean? That's really what makes it unconstitutional. It can't be inferred from the text what the statute is really attempting to punish. Yet you can be charged with 30 days in jail, a $50 fine, or both. Now, this is not an ancient law that just rested on Connecticut statute books for some years that was never utilized. It's not like the illegality of spitting on the sidewalks in Alabama or throwing orange peels on the ground in some states. No, this is a commonly used law to silence the speech of some people in Connecticut. On average, it's used about 5 times a year, which is probably more than most other statutes that regulate speech, even ones that are constitutional. So we're going to get into the specifics of what makes this law unconstitutional for both being vague and overbroad and what that means in a second. But first, let's hear about just how ridiculous the event is that triggered this whole motion of repealing a law in Connecticut. About a year ago, 2 students in Yukon were walking back to their dorm after getting intoxicated late at night. They were playing the penis game. Now, I know kids who used to play this when they were in elementary school. You just had flashbacks of what this game is. You walk around and increasingly loud say the word penis to draw negative attention to yourself. It's a really stupid game that kids play, but I'm not surprised drunk college adults are also playing the game. But after the 2 didn't get any attention for saying the word penis extremely loud on campus because no one was around, they leveled up past level 1 of this penis game and started using racial slurs. Still, no one was around, but someone overheard from afar a racial slur and went to the campus police and asked that there be an investigation to find out who said the racial slur. After 10 days of campus resources, which are state resources because UConn is a state campus, were utilized to track down the 2 students that said this racial slur, which included watching security footage, tracking who entered and left each building using tracking systems that track the IDs of students that enter and leave buildings, and much more detective work. They finally found the 2 students, compiled all this evidence, and brought it to a state attorney to charge them under the ridicule law. This is more than a bit excessive. It's extremely excessive, even in 2020. But it's a good story to use to dive into the nuance of constitutional law that holds up one of our most important amendments, the First Amendment. Now, most articles you read will state that this ridicule law violated the vagueness doctrine of our Constitution, but it also violates the principles of overbreadth. Now, I could get nerdy about this because I have a constitutional law background, so I have my wife standing by so I can read her facial expressions to make sure I'm clearly explaining this if you didn't study constitutional law in law school. First, vagueness is a term used to refer to laws that are open to interpretation. The test is, can a regular person of common intelligence guess what the law is regulating? or what you would need to do to violate the law. If a regular person of common intelligence couldn't infer that from the law, then the law is too vague and therefore unconstitutional. We don't want people being prosecuted for crimes that they didn't know existed in the first place. Now, just the word ridicule, if I saw it in a statute or any constitutional law attorney saw it in a statute, would be triggered. That's a trigger word that would signify that this law is vague. Ridicule could mean anything to anybody, and certainly means different things to different people. So right away, seeing ridicule being used as the standard in this law would make it unconstitutional. Now, this law has been unconstitutional for years, but what made this such a high-value case and being passed around to many newspapers across the United States is that not only is it unconstitutional, but it's actively being used, and in this scenario was passed by a college president, likely an attorney, security guards, police officers. Then the police officers had to pass what they thought was a constitutional law to a judge who approved it to give them a warrant to arrest these two students, who then had to go to court and be in front of another judge, also an attorney, who also thought this law was constitutional, even though Democrats and Republicans in the state Senate believe it's unconstitutional, along with UConn's constitutional law attorneys and Connecticut's constitutional law attorneys, and pretty much any constitutional law attorney. This is not a partisan opinion, it's nonpartisan. This is a trigger word that is blatantly vague. It would make the law unconstitutional. But it's also overbroad. The doctrine of overbreadth or overbroad laws challenge laws on their face, meaning you only analyze the text of the law, not how it's being applied. And if the text of the law catches more than it should be regulating, it's considered overbroad. Now, what does that mean? Laws are meant to be written narrowly, especially as they apply to constitutionally protected freedoms. So if you're trying to regulate a very thin or narrow portion of constitutional law or someone's freedoms, and you catch too much activity that should be protected, the law is overbroad. Now, the most simple example of what makes a law overbroad is a law that gives police officers unfettered discretion, meaning a police officer can interpret the law to essentially arrest anybody for anything based on the police officer's interpretation of the law. Now here, police officers have the vague doctrine here of something that ridicules a person and can use it to arrest anybody if they believe someone's being ridiculed. That's an overbroad law that gives police officers unfettered discretion to take action and silence speakers if they believe something ridicules someone else. Now, this law is both vague and overbroad, and that's not rare. Usually laws that are vague are also overbroad, and it's rare to have a constitutional law case where a law is not both vague and overbroad. Here, the law is both vague and overbroad and should be overturned in court, yet it still hasn't been challenged. Not only hasn't it been challenged, but it's super easy to change. And state senators in Connecticut already have a bill, State Senate Bill 73, on the Senate floor to be discussed and passed to overturn this law. It's only one sentence, and it only needs to be one sentence. The law simply repeals this general section of Connecticut's law that charges people up to 30 days in prison for using a term that could ridicule somebody. But newspapers across the United States are stating that it's unlikely that this bill is going to pass. Now, why is that? Well, even though Democrats and Republicans on both sides of the aisle agree this law is unconstitutional, that still leaves many, both Republicans and Democrats, that are not attorneys who don't understand the doctrine of what is and is not constitutional left in the dust. They really don't understand constitutional law enough to make a judgment on this law. And many have spoken up saying the law seems fine to them. Now, that's not a problem. We live in a citizen legislature where we're not attempting to just elect attorneys to office. But we do need to educate those in office. And the only way we can do that is through educational videos like this and constituent bodies speaking up to legislators to let them know that this law and other laws like it are unconstitutional. And that's where I leave it to you. If you believe that this law is unconstitutional, you should speak up to your legislator. You should let them know that there should not be laws in the books books that are this overbroad or vague or capture more constitutionally protected speech than necessary. And that's the point of these videos. We live in a representative democracy. The only way it can function is if the legislated body, you, the electorate, know enough about public policy to have an opinion on it, because your representatives are meant to represent your opinion. But first, you have to have an opinion. So write into your congressman, your senator, local state representatives, and let them know what you think about issues just like this. And if you have any questions, leave them in the comments. Thanks for watching, guys. Have a good night.